Good afternoon, everyone, and welcome to today's webinar. My name is Dave McClintock, and I will be your moderator for today's call. We appreciate everyone making time in their busy day to participate. Today's webinar is just another step toward our mission to be the thought leader providing Title IV compliance and consulting services to post-secondary institutions nationwide to allow schools to focus on changing their students' lives. Our presenters today are Mike Weary, Greg Rinderle, and Luke Hoy. As many on this call already know, they each have significant experience performing a large number of Title IV compliance audits. And this is the perfect time for me to thank them for all the time and effort they have dedicated to reviewing the continuous updates from the Department of Education, preparing them for today's webinar. Before we begin, we do have a few housekeeping items to cover. First, please be aware of the disclaimers accompanying this presentation. We will be recording the event today, and the recording file will be made available to all who attend in the next few days. However, many of these regulations seem to be changing constantly, and it is important to consider potential changes in the future before implementing anything we discuss today. Second, the tool you are currently using is completely interactive, so please feel free to ask questions within the widget in your viewing panel located in the upper left-hand corner of your screen. We will be answering as many questions as possible after the presentation. We anticipate a lot of questions today, so please know that we will be actively organizing them as they come through. And if some questions can be wrapped into one, we will likely combine them. Before we begin, our website does include a lot of information to help your institution keep up with everything related to Title IV, COVID-19, and the CARES Act. The link on this page will take you to a section of our McClintock Minute dedicated entirely to COVID-19 updates. In particular, I want to highlight the Q&A related to ED relief as a result of the COVID-19 national emergency, which Mike, Luke, and Greg have continuously updated with questions we have received from schools. In addition, we've created a new web page for COVID-19 resources. This page currently includes a one-page summary about the Paycheck Protection Program, and then also separately for the Higher Education Emergency Relief Fund grants for students and for institutions, along with a way to access our first webinar, which was accounting for the CARES Act. We will continue to add resources to this page to help schools navigate this difficult time. As we get to the agenda, as you can see, our plan for today is to cover the return of Title IV funds, including several R2T4 examples, handling Title IV credit balances, changes to the leave of absence requirements, measuring satisfactory academic progress, and then also answering the questions that you submit as we addressed. And with that, I'll turn it over to Mike Weary, who will get us started on the return of Title IV funds.
Thanks, Dave, for kicking us off today, and thanks for all the attendees who have taken time out of their afternoon to join us. I get the pleasure of doing everyone's favorite subject, the return to Title IV calculation, which is certainly a nuanced and can be tedious calculation at times, made more so by some of the Department of Education's guidance, which they have given to us. Obviously, their guidance is obviously meant to assist schools, but at times when guidance is issued, it just creates new questions for schools as they try to interpret it as well. So just a little background on the guidance the Department of Ed issued. The CARES Act has enabled institutions to waive Title IV refunds during what they defined as the cover period. Obviously, Congress was looking at ways to provide relief to the two institutions during the national emergency. And then, of course, subsequently, EDs issued some specific guidance to help interpret the congressional action. The May 15th guidance that Department of Ed issued provided some clarity in some areas that was positive. It also tightened some of the interpretations that was originally thought and provided a more narrow scope. And so that has led to more questions and some discussion of what department's ultimate intent was, of which we're going to go through that. I think of all of the areas in the May 15th guidance, this is the one that we've seen the most questions on that's come out. The April 3rd guidance provided general relief from March 5th, early March to what was June 1st, 2020. And that seemed to be the time frame we were looking at, which would have covered the R2T4 calculations as well. The May 15th guidance that Department of Ed put out has certainly changed this interpretation by indicating that the eligibility for the return to Title IV relief has to be for payment periods or periods of enrollment that started on or included March 13th. And so that's where the narrowing of the interpretation certainly came into play, which caught us off guard and a number of other people, I'd say, in the industry as well. Just as I was thinking about why Department of Ed did this, this is just my own interpretation, that department may have been taking the assumption that once schools transition to fully distance ed, that any new student enrolling was coming in under that new educational modality, that they knew they're enrolling in a fully online program. And as such, the emergency relief shouldn't be applicable to them and may just be, and just tighten down the role to the people who really were impacted by the transition of going from on-ground to distance education. And just taking the theory that this was going to provide a little less relief to schools. It also provides less risk to the taxpayer in regard to money going out. And if Congress wants to pass further relief, they just defer that back to Congress. So by tightening the rule, the department says we're going to just implement this regulation for the students who we think were ultimately impacted and let Congress decide if they think more relief is necessary. And again, that's just my own interpretation, not through discussions, but just as I've considered what their thought process may have been. So one of the things that department did say in the May 15th relief was trying to determine if the student's withdrawal was COVID related. So what they said is that an institution underwent a change in their delivery of education, that any student who withdrew in that covered period that would have included March 13th or the payment period included March 13th would be a COVID-19 withdrawal. So that was one of the positive things they did. So now you don't have to figure out, was that student's COVID-related drop or not? If you moved students from ground-based instruction to distance learning and they're in that period, they're a COVID drop. If you close campus housing or other campus facilities, they're a COVID drop. They listed other interruptions, which we've interpreted to be, loss of a clinic site, loss of externship sites. We'll talk about later, there is some leave of absence relief as well, but if you couldn't find, or if that leave of absence relief didn't work for your institutions and you had to drop students, they would be a COVID drop as well. So this is good guidance, and I think did take some subjectivity out for schools having to figure out, well, why did they leave or why didn't a student leave? The one caveat we'd make, though, as anything, ED has not waived any relief in regard to conflicting information. So if a student tells you they're dropping and it's not COVID related, I would certainly rely on that information. And we've heard that from other sources as well. Any direct information you have from a student that conflicts the relief you're getting, certainly follow that direct relief. I think that's a good practice. Anytime you've got better information, their relief was really unrelated to the COVID-19 crisis, then don't give them the R2T4 relief. My guess is you're not going to have many of those, but I'm sure somewhere at some institution this will come up occasionally. And the best practice would be to follow the exact information the student provides you if you receive it. So in the department's May 15th guidance, as I mentioned, they talked about students that were enrolled in a payment period or period of enrollment that includes March 13th. They're calling that the covered period, are eligible not to have R2T4 refunds made. This appears to include students who dropped prior to March 13th. If you read the announcement, it mentions the covered period March 13th, and then it says, and students who subsequently withdrew. I've heard varying interpretations of that. I've heard institutions or industry colleagues that have interpreted that to be withdrew after March 13th. I've heard others say, no, that's just more generic, that they were in a payment period and they dropped from the institution. Seems like the intent is that anyone who is in that payment period and withdrew is eligible for this R2T4 relief. So they could have been a drop in January, February, early March. The rationale is that the national emergency was starting before the announcement was made on March 13th, and you may not have known what was impacting that student. And so the relief would extend prior to March 13th. I think that's really applicable if you look at institutions that are in Seattle, possibly California, certainly New York City, because they were certainly being impacted by the emergency before institution, probably where I'm located in Pennsylvania, so just kind of making a broad guess in that regard. Certainly students who dropped after March 13th are eligible. And so I've seen institutions take different positions. I'd just say if you feel you're not going to provide the relief prior to March 13th, have a basis for your reason and to document it. Hopefully Department of Ed may issue additional guidance just to clear that up for institutions. If you have refunded monies to students who are now eligible for the relief, Department has said you should go back and get that money back. So you can redisperse the funds on the student's account card. You go ahead and adjust COD accordingly to remove the refund, and you can get the funds back from G5. So certainly, if you're taking the position, regardless of whether you're taking a position, the drop is for the whole payment period or just the period after March 13th. If refunds have been made, go ahead back and claim those refunds and get them back to the institution. Reminder, and we're going to talk about this a little bit later, and the reminder is that the CARES Act will cancel the loan obligation for that covered period for any student that withdrew in it, along with adjusting their Pell lifetime usage and their SULA, so there's no detrimental impact. So that's the reason the schools get to keep the funds. The students aren't going to be on the hook for repaying it, nor for their SULA lifetime usage amount as well.
Mike, if I can just add real quickly, I think I would just say that the last point that Mike went through is why our interpretation is that the relief applies to all students in that overlapping loan period. The electronic announcement on May 15th specifically outlined the points here about redispersing the Title IV funds, which to us is indicating the expectation that all students who are enrolled in that overlapping period should be receiving the relief, even if their LDA occurred prior to March 13th.
Mm-hmm. So I'm going to turn it over to Greg and then on to Luke, who are going to go through some specifics of the R2T4 calculations and covering some items related to post-withdrawal disbursements that have come up in the ED relief as well.
Thank you, Mike. When they came out with this guidance, they said they used the word must include the March that overlap in the March 13th. It's not a may that the department sometimes has used. So we interpret that that has to include that time period. So what steps would be required? You're going to repeat the return on Title IV all the way up to step number 5. You would not be doing any COD adjustments or making any adjustments on the student's ledger card. There could be flexibilities on all students or at the individual campus basis. I feel that it's a little bit easier to kind of go through as an example. The example I will be looking at is the one that says Greg Renderly. We're going to go over that example. With some caveats to that example, we are going with that verification was completed, the ICER was valid, and the loans were certified before the last day of attendance. In this calculation that we can notice here, all aid was dispersed before the LDA, so it's included. The Pell's in there, the loans are in there. We go through all the steps. The time period, which it overlaps that March 13th date. The start was 1/6/2020 to March 21st, 2020. The student dropped right before my birthday on February 19th. So we have a total percentage that they earn would be 59%, 59.2%. We went through the calculations. The student would earn $2,456.80. You go down to the next step, the student would not be eligible for post-withdrawal disbursement because all aid was dispersed. We go to step number K, the amount that was paid out to the student minus the eligible amount that was paid the student earned will give you the amount that needs to be returned. It will be $1,693.20. Now we do step 5, which would be your institutional charges. The institutional charges right here is $6,238. The other charge, there is no other charge. I just moved it in the wrong box. So L should be $6,238. We're going to take the percentage from the first half, bring that over, and we have a percentage of 40.8%. We're going to times that by the amount of unearned charges, times your 40.8, which will give you $2,545.10. We're going to return the lesser of the two of N and O, and this N and K. So that will be the $1,693. This amount will be, what's the amount right there will you be, when the department requires you guys to start reporting, that'll be the amount that you're going to report to the department at $1,693. We're going to go into more, I'm going to turn it over to Luke to have a few more examples when we have post-withdrawal disbursements.
And Greg, just to make one comment before you go on, the reason of doing the R2T4 calculation in its entirety is that you've got the exact amount to report to ED. And we recommend going all the way to the step where you get to the priority of refund and then filling in 0. From at least from an audit trail as well, there's a clear, I hope we're all going to remember at the period of time we're in when we're doing the audits next year. But still, to have the full calculation done and then 0 written down in the priority of refund also is a clear delineation that no refund went back, which will help. Our memory should be good, but there's a lot of ED changes going on, and just as you go back through audits, our brains never remember as well as we think they should.
Okay, thank you, Greg and Mike. I'm just wondering, I wasn't able to see the R2T4 example that Greg was walking through. And I'm just wondering if when I go through mine, whether I need to press something different to make sure it appears.
You just need to pull it up from the network. So the attendees can see it in the resource box, and they're pulling it up individually, and then you'll just need to pull it up on that second screen.
I do have that open. I was just making sure that I wasn't missing something. But
Yep.
Yeah, so we've touched on this a little bit, but basically what we understand to be the intent of the R2T4 relief, as well as the corresponding instructions in the May 15th electronic announcement, is that a student who withdraws during a covered payment period where the withdrawal was due to COVID-19 is entitled to receive all of the aid that dispersed and that could have been dispersed during that payment period. So it begs the question, why do you even have to do an R2T4 calculation if, regardless of the percent that they've earned, they're going to keep all of the aid from that period? And it is due to the reporting requirements that Mike and Greg have both touched on. We know that ultimately, or eventually, you'll have to report to the Department of Ed how much Title IV funds the student retained, or that otherwise would have been refunded had the R2T4 waiver not been applied. So we've been suggesting to schools, when they go to calculate these R2T4s where they've applied the R2T4 waiver, to list all aid as dispersed, and that's due to the language that it was in the May 15th announcement, which I'm trying to advance the slides here. Okay, we're back to where we're back on the same page here. So we copied in some specific language from the May 15th electronic announcement that we feel supports our position of putting all of the aid as dispersed in the calculation. It reads, if an affected student withdraws prior to some or all of their aid being dispersed, the institution should proceed with making any remaining disbursements for the payment period and then follow steps 1 through 3 above. So obviously that's taken out of context, but the steps that it's referring to here are the same that Greg outlined a few slides back, and that is completing the R2T4 calc, not making any adjustments in COD, and not making any adjustments on the ledger card. So if you're being instructed to disperse the aid and then calculate an R2T4, we feel like that implies that the department would have you treat the aid as if it did disperse, even if it was posted after the student's withdrawal date. A second point that we feel like supports our position within the 515 EA is that within the reporting requirements guidance, in terms of the amount that you're to indicate that the student retained that they wouldn't have otherwise, it does reference specifically step 5 of the R2T4 calculation. And for those of you who either calculate R2T4s for your school or are familiar with the process, if there's aid that's included as could have been dispersed, which we will again go through on my 2 examples, it's possible that you wouldn't even get to step 5 of the R2T4 calculation. It might stop you at step 4 if it's showing the student is eligible for a post-withdrawal disbursement. So again, we feel that the student is entitled to all of the aid in the payment period with only one exception or a couple of exceptions. The exceptions are outlined on page 5-47 of the 1920 handbook. One of those is for a student who is a first-time borrower that is attending a school that has a high cohort default rate. If they withdraw before attending 30 days of their first payment period, then the school may, while they may include their loans as could have been dispersed in the calculation, they would be prohibited from making a PWD from those loan funds because the student did not reach 30 days. And we feel that is somewhat supported by the language in this electronic announcement, in that it says a situation that would normally result in a post-withdrawal disbursement. And so under existing guidance, that's not a situation that would result in a PWD. So I'm going to move to example number 2. And this student is me. I'm in the same cohort as Greg, and I received the same amount of aid as well. Now for me, my loans dispersed after my withdrawal date. But based on the guidance that we're talking about right now, the school has included the loans as an amount that was dispersed, as opposed to where they would normally be over on the right-hand side under the amount that could have been dispersed. Greg and I were in the same class. We were both started on January 6th. Both withdrew on Greg's birthday, February 19th. And so that equates to 59.2% of the payment period that we completed. Now, had my school included the loans as could have been dispersed, when everything is the same up until step 4, when they would have reached here, they would have compared the amount that I earned, the $24.56, to the amount that was dispersed to me, which would be $1,016 of Pell. And then in step 4, it would have said, okay, stop here. The student's eligible for a post-withdrawal disbursement of $1,400 of their direct loan. Now, again, going back to the reason that we are talking about this is if you're to report how much aid that I received that I wouldn't have otherwise, it's not as clear if you do the calc with including the aid as could have been dispersed rather than dispersed. If you do format it this way, the end result is the same as what it was for Greg's R2T4 calculation. And our last example, handout number 3. This is Mike. He is a first-time borrower. He is attending a school whose cohort default rate is greater than 15%. and he is in a covered payment period because it includes March 13th. The start date you can see is March 2nd. The scheduled end date is May 16th. But he's withdrawn before he attended the first 30 days of the payment period. So based on the percent that he earned, it's showing that he would actually be eligible for a post-withdrawal disbursement under normal circumstances. But this is not a situation that would normally result in a PWD. So we would recommend that the school not award any portion of that loan, but the amount that he earned or the full amount, but rather hold off on awarding that. Now, in his case, the amount that the school would report as retained would be 0, because he earned all of his Pell and the loans he was not eligible to receive anyway and didn't receive them. Okay, I think we're going to kick it back over to Mike now.
Thanks, Luke, for going through those examples, and thanks, Greg, as well. So one of the things schools need to consider is the reporting requirements under the CARES Act. Under the CARES Act, the refunds that are not being returned as a result of the act do need to get reported eventually to the Department of Education. Those reports also, as my understanding, could eventually go up to Congress for analysis, review, understanding the benefit of the in essence the subsidy provided, and whatever else Congress wants to do with them. Schools should be certain that they're complete and accurate. They could be subject to Freedom of Information Act. So, like any reporting to ED, you want it to be as accurate as possible. So what they're going to want you to report is identifying information for each student. I've not seen the specific items yet, but obviously without personal identification, assume in some ways. But the department's also going to have to update their systems and account for this. So you're going to have to report identifying information for whom the refunds were made. They want the payment periods, and the quotes that I indicate there are actually in the electronic announcement, so the begin and end dates. I don't know the reasons they put the quotes in. It could be that under the relief ED has provided is institutions have been allowed to lengthen their terms and also request that terms be shortened. So we are interpreting that the term payment periods begin and end dates will be the actual ones that occurred, not the ones that were originally set up. And so again, we're hoping when the reporting instructions come out, there'll be more specific guidance on that. The amount of Title IV grant or loan that each student received for the payment period when they withdrew, obviously excluding work study, and then the amount of Title IV grant or loan that the institution did not have to return because of the relief provided in the CARES Act, which, as we indicated earlier, is why the R2T4 calculation has to be done. Would they start compiling this list now if you haven't done so? Yeah, I think it's easier to do it as you go along than trying to go back and do it at one time. I would certainly consider secondary reviews internally to be certain the information is correct. For some of you that may not be able to review every single student on it, but at least do some spot checks, and along with some completeness checks to be certain you've included everybody. We're recommending that schools, I've had schools ask, to put it this way, to say, should I post these refunds on my account card, my ledger card, and then reverse them? I don't think, departments, I think, are not going to say one way or the other. That's too granular of a internal accounting process for them. I think you can definitely put them on your account card. That would give you a mechanism and a way to possibly pull a list to compare to an Excel spreadsheet to be certain it's complete. I think whatever codes you use, you'd want to set up a new code and be certain that these transactions that you're adding and then removing, since you're not making the refund, does not mess up your 90/10 calculation. That does not mess up other R2T4 calculations. That does not mess up institutional charges. So I think you just want to be certain if you do put in your ledger cards that the codes are very clear and that you test your accounts receivable balances to be certain nothing has changed. Because if you do add it and add it correctly, it could be a way then you could print reports from your system for all the students with this code to help identify the least the students who would have had refunds that you didn't have to return in the covered period. I think it's one of those areas that if you do go down that path, do a couple of students, test it, figure out all the items you want to verify, and before you start posting it to large numbers of students. The reporting, the CARES Act has raised one question internally that we've thrown around that we think we know what our opinion is, but we'd like to see the Department of Ed clarify it. Is if you look at the ED's 515's guidance, and you can see the area I've put in bold, they talk about reporting to ED specific information for whom it was not required to return Title IV funds for each student who meets that eligibility. But if you look at the CARES Act, the next paragraph, which is language directly from the Act, they talk about canceling loan obligations for any student who's in that covered payment period who withdraws. So that would mean that students who drop and don't get a refund still need to be reported. And I guess if you look at it from an equitability standpoint, that makes sense. If I drop and I'm going to get my loans canceled and you're going to get to keep the money, well, then how come a student who drops at 80% doesn't get their loan canceled as well? So I think logically it makes sense that you're reporting not just the students who owe refunds, but all students who withdrew in that period of time. We've heard from another association just today that seemed to be in agreement with us, and hoping this is something the department will clarify more specifically when they provide the information about direct reporting to them. What I would do now, what we're recommending to schools, is I would track both cohorts of students. Maybe if you have an Excel, if you've got a tab with the students who had refunds and a tab for the students that didn't have refunds, you have both lists compiled, and then if you have to report all students, you just combine the two lists. So I would start tracking them now so you know everybody. And that may be an easy way for completeness if you think about your student information system. If you have the payment period and you're querying everyone that drops, then that's your population, and then your Excel spreadsheet should have everybody on it. It's just a matter of which tab are they on. One question that came up from a client, and I want to just caveat this screen. There was another comment we should have added here. This exit interview question we're going to go through came up from a school that asked if I have a student who attends just one payment period, and so they don't have loans from any other payment period, and the loan is now going to be canceled. Do I need to do an exit interview? And our response to them was no, because obviously there's nothing the student has to pay off. But you didn't send a refund back on that. And normally you do a refund, you notify the student that the refund's been made, and if the whole loan's paid off, then you're notifying them of that. Our thought would be, you don't have to provide them exit interview material, but you may want to send them a short statement just saying, hey, under the CARES Act, we didn't have to return your loan. They're going to cancel it. You can include the language right from the CARES Act and said you're not going to have an obligation for this one period. You borrowed for one loan period. It's been canceled because you dropped, and there's nothing you're going to need to do. So at least the student is aware of the loan cancellation. Some students are probably aware of that. Other students may not be. I would say if a student dropped and they had loans from previous periods, yeah, you should still be doing an exit interview, obviously, because they'll have prior period, the loans aren't getting canceled. So just don't want anyone to misunderstand that slide. And as we talked about, ED is going to want all the information reported. They are still developing the process to fulfill reporting requirements. I know we're getting lots of questions on it, understandably so. Schools don't want to be remiss on not reporting. ED in their May 15th announcements said they're requesting patience, so I can only imagine how many thousands of questions they're getting. They are still trying to figure out and develop systems to report this information so they can do the forgiveness of loan repayment obligations, relief from the SULA requirements, and relief from the Pell lifetime eligibility requirements. And reminder, there's HERF reporting that schools have to do as well, so they're figuring out how that HERF reporting has to be done. I know I talked to someone in the last month. If you add up how many thousands of institutions are out there, I don't know if it's 3,000 or 4,000, and how many student records are going to be reported to the Department of Ed because of the CARES Act and the relief, it's in probably the hundreds and hundreds of millions of records. And so this is almost like, think of it like gainful employment. It's an astronomical amount of information that's going to them. And I'm sure they're just asking for patience on it. So when this information comes out, I'm sure it will be disseminated by multiple sources and you'll be aware of it at the appropriate time. And so at that point, I'm turning it back to Greg to get into Title IV credit balances.
Greg, I think you're on mute.
Sorry, guys. Thank you, Mike, for turning it over. I apologize for that. What I'm going to talk about right now is your tuition refund policy and credit balances. With all the guidance that we've been talking about, the Department of Education, you still have to apply by your institutional refund policy or your accreditation or your institutional or your state's refund. They also gave you an option that you may revise your tuition policy. So you have to do it on the program level. So you must document it and disclose it to all students. Student may have the right under the state law to enforce some policy if they want to. You may not amend it by student. So it has to be, again, on the whole program. Some things that you want to be considering when you're thinking about that. Do you have multiple states that you operate your business in? If you do, you might have a stricter state, or say maybe, for instance, like Texas or New York, that might be stricter, that you kind of wrap all of your institutional refund policy around. And now you would have to adopt that for each different state. So is it worth the time to do that? Also, what kind of student population do you have? Do you have a lot of your students trying to get, are they getting stipends? Are they not getting stipends? We need to look at it also as now, if they have this in the calculation, the loans will be forgiven. Do they need a stipend? So we want to look at every school will be unique, and every school has to be thinking about some of those factors to make sure that do you really want to go change it? Because then you're going to have to change it back after this requirement. So is it going to be worth the whole process of doing that?
And Greg, I just add one comment. I think we've had a few questions on this. I think this is an item that really comes into your regulatory counsel. As CPAs, we're not lawyers. We don't have a lawyer here. It could vary by state law, as Greg mentioned, depending on what each state has. And so it's something I think you really want to run by counsel. We've seen some people consider it and to do it and have come up with some unique ideas to ensure they're treating what they feel is treating people equitably. But they've had regulatory counsel sign off and they've come back to us and say, here's what we're going to do. So, but they've been in limited states in the sense they've only had to deal with one or two states. They haven't had to deal with a broad number. So it's something worth considering. I know other clients have said they just didn't think it was very feasible and doesn't think it was worth the effort to try to do it, especially if you look at the covered period that's been tightened, how many students would really be applicable. I do think it's also an area you're opening yourself up to student complaints. One student gets it, someone else doesn't, different states, different attorney generals. To me, there's just a lot of risk with this, and so vetting it thoroughly is prudent to do.
Thank you, Mike. Resolution of a Title IV credit balance. The department has not given any guidance or relief on the cash management. They have not been unchanged. So when you do the calculation, if there's an existing Title IV credit balance, that would need to be returned within 14 days. You may have an authorization form on there. We are recommending, because now circumstances could have changed during this time period. So we recommend that try to reach back out to the student and see if they would like it go back to the lender or would they now like it go back to themselves. And that's also consistent with some of the things in the handbook they talk about. And then if you have the opportunity, they might want to sign a new one under this condition that say that we authorize it now to go back to me. It was different, so I would just get the documentation, the audit trail that they changed their mind in this case, just to have something that that they changed their mind at that point in time, that you can send the money back to the appropriate, to the lender or to the student, whatever they did in that case. And under no circumstances should you refund the loans from the covered period where the student may receive the CARE Act waiver. So you don't want to return all these funds back to the students right there, because they're going to be written off. So you want to watch out for that on that part right there. So, and also remember on your authorization form, looking at your language that you have on there of how they signed off on your authorization. So pretty much nothing's really has changed on your authorization of a credit balance and how to handle that. It's just some of the things that you might want to be double checking on and asking for more clarification on student status. I'm going to turn it back over to Luke for some LOA questions.
Thanks, Greg. One quick correction, because I think you meant to say in no circumstances should you return the loans to a lender for a covered period. I think you said the student, but our
yes, the lender. Sorry. Thank you, Luke. That's correct. Yep.
Absolutely. So yeah, if their loans are going to be forgiven anyway, you should not return them to the lender. Before I jump in here to the details on the LOA relief, just wanted to remind, and Mike had alluded to this earlier, what we understand is the covered period for this relief, and really all of the provisions that have come out either in the electronic announcements or the CARES Act. Most of them, with the exception of the R2T4 waiver and the distance ed rules, are covered for payment periods that begin March 5th through June 1st. And the relief is at this point supposed to stop or end at June 30th unless the payment period crosses over July 1st and is attached to the 1920 award year. So as of, and that was defined in the April electronic announcement, that time frame. It wasn't changed to our knowledge in the May 15th announcement. And at this point, that is still the time frame that we're looking at for both what I'm going to talk about, which is the LOA relief and the satisfactory academic progress changes. So as for the leave of absence policies, the CARES Act did waive the requirement for term-based programs to have students return and resume training at the same point from when they began the LOA. And this was the single biggest factor that under existing regulations effectively prohibited term-based schools from administering or trying to grant LOAs. If a student left in the second week of a semester and returned in the fifth week, not sure how they would resume at the same point if they lost 3 weeks. So really not many schools that we know of who operate term-based programs are using LOAs. But that does not prohibit them from creating a policy, even if it's temporarily during this time. The requirements that you must abide by are that the request still must be submitted and in writing, including the reason for the LOA. And the reason, it's not stated here, but it is obviously it has to have something to do with COVID-19. Now, the request itself, under normal circumstances, would have to be made before the student went on LOA. That requirement is also being waived as part of the CARES Act change. So not only for an individual student, but for an entire class of students, you may place the student on an LOA and then subsequently obtain their request. And so if you have a program, that doesn't necessarily work well via distance education, you are permitted to place an entire class on LOA. If you do utilize an LOA during this time, there are some, you'll want to reassess the cost of attendance that you're using for that person's period of enrollment. And so in the May 15th announcement, the department pointed out some things, mostly just wanting to make sure that schools weren't double counting the tuition for the coursework that they started before the LOA if they have to continue it on after they come back. So they want you to prevent that from happening, but they do indicate that you're permitted to include living expenses for the duration of that time. Once again, the exemption for the requirement to have a student return at the same point, the requirement to have a student return at the same point in their program is temporarily suspended. The last second point on this slide here is actually taken all the way back from the March electronic announcement. It had a FAQ document attached, and this was one of the questions and answers that was published in that document. And it stated that a clock hour school can put a student in an externship on a leave of absence if the expectation is that they'll find placement within 180 days. And that was previously not permitted, but now, as of that announcement, it was. Now, in the April electronic announcement, the wording to this guidance became a little bit more general, and so we have concluded that we're assuming that this now applies to credit hour institutions as well. However, if you look at the CARES Act language, it does indicate that in order to receive this LOA relief, that the student is still required to return within the same semester or equivalent. So it's not likely that you can give them a 180-day LOA and have them come back in the same term, because while schools are, we understand that some are extending their terms, we don't expect that any are extending their terms by that much. As for satisfactory academic progress, you are now able to exclude attempted credits that the student was unable to complete as a result of COVID-19 from the PACE calculation and the SAP evaluation. The way that works is that credits are excluded from the denominator of the attempted credits when you measure a person's PACE. And there's a example in the May 15th electronic announcement that illustrates this pretty clearly as far as how that would work. It does indicate in the guidance that the failure of the coursework must be related to COVID-19. It's not clear whether you can apply the same assumption that you can for your R2T4 waiver, where if a student was moved from ground-based coursework to distance education and subsequently dropped, that was, as a result, you could assume that was, COVID related. So it's unclear, but that could be a factor that you consider when you're, making your determinations with SAP. As I mentioned, we feel like this is covered under the April electronic announcement in terms of the time frame and the payment periods that you can apply this guidance to, which are any that begin March 5th through June 1st. The May 15th EA includes some allowable circumstances that you can reference in terms of showing why a student failed their coursework. You might consider also if they've had a history of poor attendance, and if that continues, it might not be unique to the current circumstances, but just a student who doesn't keep up good attendance. So what we would recommend is that you do include at least one of the reference one of the circumstances that are specified in the May 15th electronic announcement, which include, obviously if the student becomes ill or one of their family members, it could be from a loss of childcare or just difficulty with the whole distance education format. It's not for everybody. For the SAP relief, it doesn't necessarily have to be that the student files an appeal on their own behalf. The school can, from our understanding, can document this in the student's file along with the SAP calculation, and then indicate through communication that they've had with the student that their circumstances have changed because of COVID-19. So the SAP relief is fairly straightforward, and we really haven't received a ton of questions about it. Where we have received more questions is around incomplete grades. And so there is some tie between that and SAP, in that a school's SAP policy must explain how GPA and PACE calculations are affected by course incompletes, among other things. And so what the situation that we're in right now, there's for schools that have courses that have a clinical component, in some cases the students completed the in-class portion, but the clinical has been on hold really indefinitely. So they've asked, can we extend the time frame that we give students to complete their incomplete coursework? And from our research, there's nothing that we found that defines, it can't be more than X days. Typically what we've seen is it's a week or two that's given for that student. So if you update your policy with the catalog addendum or internal memo, we would be okay with that in theory. Just keep in mind that if you extend it very far and you continue to pay them Title IV for subsequent payment periods, if when the student completes the incomplete work, it results in them potentially failing the course that they were in at that point, then it's possible that there could be SAP issues that affect the student retroactively, and the aid that you've paid them for subsequent payment periods could all of a sudden become ineligible. So that's one consideration that we've made to the schools that we've discussed this with. All right, and I think we have one final item, and Mike's going to talk about that.
Yeah, and just the one final thing on the SAP policy, Luke, is, my understanding is the GPA has not had any relief. So that SAP policy is only for the PACE and not for the GPA. So the school should keep that in mind.
That's right. And the way that makes sense, I think that kind of makes sense because generally a dropped course would result in a W grade, and those typically don't affect a GPA calculation. So that's the way that I understand why they specified the quantitative component in the CARES Act.
So the final item I just wanted to touch on was audit timing. Just to, probably everyone has seen this, but the Department of Ed did extend the audit deadline. So extended for 6 months. And so we assume this is obviously December 31st, 2019 year ends. We assume this goes through, obviously June 30th, 2020 year ends. Some of the other relief they mentioned goes up through December 30th, but does not include December 31st. So we're making an assumption that December 31st, 2020 year ends would not have an extension. I think the June year ends coming up certainly do. I know we have a 9/30 year end client out there. I think we'd have to evaluate and get more information if they would be subject to that deadline extension as well. If they even need it, they may not. It's just, so I think if you have a year end coming up in July, August, September, it may just be something we ask ED to get additional clarification on to be certain it applies the extension. If you're a 12/31/19 year end and you're going to submit your audit after July 1st, 2020, from our understanding, it would appear to be that the new composite score rules that become effect July 1, 2020 would become effective. And as a reminder, these composite score changes are in the bar defense to repayment regulations that were passed last September and become effective 7/1/20. If you've been following, the House and the Senate passed a resolution to overturn and stay with the 2016 bar defense regulations, and those were vetoed by the White House. And so Congress would now have to pass an override of 2/3 majority in both chambers. From what I've heard, I don't think that's likely. So at this point, we are planning that the new borrowed offensive repayment rules and composite score changes go into effect July 1, 2020. That does make some changes. They adapted for the new lease standard, which I don't think will affect many private institutions at this time. But there is new treatment for long-term debt. And there is a new supplemental schedule that would have to be included. So if you're going to submit your statements after 7/1/20, be aware that your composite score could be slightly different than projections you ran. You'd want to look at those now, and you'd have to have the supplemental schedule in there, we believe, unless the audit would be rejected as well, which would allow the Department of Ed to compute the composite score under all of the changes that are in those borrowed offensive repayment regulations. So it's a little more work for your auditors to get it done. So we're advising schools, if you can get it done before June 30th, 20, without too much effort, we're advising to get it done and get it submitted just to be safe. And at that point, I'm going to turn it back to Dave for our Q&A.
All right, Mike, Greg, and Luke, thank you so much. That was a great presentation. I know it continues to clarify some things for me. Now is the fun part where I get to put you guys on the spot with all the great questions we've received from participants. Before we move on to that, just briefly, so a reminder to everyone, we did receive some questions. In the next few days, we will be providing a recording of this presentation, all of our slides, and all of the examples to everyone who attended the call. So if you missed the beginning, if you want to go back and review things, this will all be made available to you as you work to try to stay compliant with all the changes that seem to be occurring very quickly. And then I guess I'll start with it, and we will be updating our examples. We received a couple of questions from participants, guys, about so the examples we have for the R2T4 are all credit hour based. I think that the clock hours should be very similar. Obviously, you're just using the proration for the clock hours instead of credit hours. Is there anything you can think of that would make those different? And just to let people know, we will create each of the three examples in the clock hour form as well to make it available to people.
The clock hour for me are more confusing, and I do less of them, so I created the credit hour just because it was easy. So I would refer that question to Greg and to Luke.
No, and they're very similar, and would be more than happy to do so.
Yeah, it doesn't change the way that we would suggest you treat the disbursements. If it's payment period or period of enrollment, which for the credit hour, this is credit hour, but for standard term programs, your option is payment period. For non-term and clock hour, you could do a payment period or period of enrollment. Either way, it has to include March 13th in order to apply the R2T4 waiver. But in terms of all the details of what we spelled out, the rest of it, it would be no difference in how we'd advise a clock hour school.
Perfect. And that was a great segue, Luke. You might be able to answer the next question as well, which we've seen a number of times, which is just to reinforce maybe how, what the requirements are for students who begin terms that start after the March 13th date. So it starts March 15th, April 1st, May 1st. How does that apply? How does the R2T4 waivers apply to those students?
We don't think that they do. The payment period has to include the date March 13th. And we've been holding out to try to see if the department would kind of maybe backtrack on that. But to my knowledge, they haven't. Mike, Greg, would you add anything?
At this time, they have not, but they may backtrack on that. So, but wait to hear more.
Yeah, I was just going to say, from all the colleagues I've talked in the industry, clearly everyone's in agreement that any payment period or period of enrollment that does not include March 13th is excluded from the R2T4 waiver. And that was the narrowing of the guidance that caught, I think, everybody in the community off guard.
So it makes sense then at this point to, I know that we've had conversations where we said, maybe hold off on making the actual refund until it does become clear. But if it hasn't been adjusted yet and you're sitting on refunds, obviously it's probably getting close if the term started in April to 45 days. And so at this point, we would advise you to go ahead and proceed with the refund. Yeah,
and that's a good comment, Luke. From a standpoint of an audit next year, I think if that payment periods outside of March 13th and the refunds aren't timely, I do see that's something that would end up in a late refund. So institutions would not want to have that happen.
Potentially.
And I would just add that.
You go ahead, Dave.
I would just add of all the communication we've had, it does really seem to have narrowed it. Even if you can specifically identify a student who did withdraw due to COVID-19, they were a positive test. They had a family member who was a positive test. You would think that they would be covered, but the communication that we've heard, I think pretty much unanimously to this point, would be they do not qualify for the refund R2T4 waiver, but pending there could be future communication about that. All right, Mike, maybe a question for you. We've received from a couple of different people, and it just relates to the 90-10 calculation, which is not something that we did address here, but there are questions about the potential impact of refunds that are being kept on a school's 90-10 calculation.
Yeah, it's a question I don't think I had thought about, kind of in the details. But my guess would be just thinking out loud that if you haven't returned the funds, there's still money you've received, and I would include them in the R2T4 calculation. I'm thinking through the template that you back off certainly refunds that you've sent, but this is money that you've now kept. So in some sense, it's paid for tuition and fees. Now, the flip side could be that if you end up doing some tuition waivers, as Greg talked about, and changing your policy, then your institutional charges for those students would go down. And so now if you've kept money and there's no institutional charges, the 90-10 is limited to the institutional charges. So that'd be one way that it wouldn't be detrimental. I think it's just an item, there has been some other 90-10 relief put forth to ED, and they haven't spelled anything out on it yet. So it could also be, hey, you're not allowing us to keep all this money, and if I'm 89%, now this is going to have a detrimental impact on me. It's like, as usual, one positive happens, but now it hits you another way. I think it's a question we could put to ED to see if any relief is forthcoming. Similar to default rates. So there's lots of other questions that have been posed to ED that they haven't answered yet, and I expect there's more guidance forthcoming in regard to financial responsibilities and 90-10 of those type items.
Yep.
I think
I would say for that,
I'd include it in until I get further guidance at this point.
Yep, and I would say certainly as we go through this Q&A again, some of these are going to be putting the three of you on the spot, and I'd say the caveat for all of these that we will continue to get updates from other from attorneys, from other advocates for the space through the Department of Education and other groups that we're talking to. So maybe along that same vein, and Luke or Greg, if you want to weigh in here potentially, what about if there's a student whose verification has not been completed? How do we think that would impact the post-withdrawal disbursement relief being provided as of the 5/15 electronic announcement?
I don't have it memorized, but around the same section that I had referenced on my one slide, page 5-47, the preceding page does, we suggest following the rules on the preceding page for figuring out, determining which aid you should include in the calculation. And so, yeah, offhand, I don't have memorized whether verification is incomplete, if you can count Pell or direct loan, but it is, our stance is that if you follow that guidance from the FSA handbook to determine what aid should be included, and then also considering the amounts that can be included but could never be dispersed from the next page, that's our approach to that.
Okay. Yeah, thanks, Luke. Greg, maybe you can take this one, but you're not getting off easy. So normally you can make a post-withdrawal disbursement for the first disbursement of loans, but there's restrictions on the second disbursement. Does the May 15th electronic announcement provide the availability to make a post-withdrawal disbursement for the second disbursement in a loan period?
In the reading of that, it does not. They can still be, they would be included in the calculation, but they would not be eligible to be dispersed. And I think Luke talked about that on think it was 447 about the late disbursement requirements. So they would not
That's
be able
what,
to.
exactly
Go ahead.
I'm sorry to cut you off, Greg. That is one of the exceptions noted on page 5-47. And we use that as the example in the Q&A blog that Dave referenced at the start of the presentation. So that is one of the covered exceptions, along with the first-time borrower, along with, we touched on clock hour schools and non-term, and I meant to add this, but if you are a clock hour school and you calculate an R2T4 based on the period of enrollment, if there's aid from the second payment period that's there that could have been dispersed, if they didn't complete the necessary clock hours and weeks to earn that's one of the other exceptions. So keep that in mind, that aid from the second payment period could be included. We feel that's the only type of aid that should be included as could have been dispersed in the calc, but that even if the R2T4 shows they could get a portion of that as a PWD, you're prohibited from dispersing that.
Yeah, and I think the key was on slide 13, where we quoted Ed's guidance, and where they had in parentheses, they say a situation that would normally result in a post-withdrawal disbursement. And so all those things Luke and Greg highlighted on page -547 would not normally result in a post-withdrawal disbursement. So that is how we're interpreting it, which is why those second or subsequent disbursements would not be eligible. Try not to read anything past the letter of what they said.
All right. Mike, so for the R2T4 period of enrollment, if a school was required to close for a short period of time, and so they had to change the dates of the payment period, what dates should they be using as they prepare the R2T4 calculation?
I think, based on the department, putting the beginning and end dates in quotes, I would think and may defer this back to Greg or Luke, I would think on the R2T4, you would use the dates of the actual term if you changed them, if you've had to amend it. And if you've had breaks of more than 5 days, I would assume if you've been closed, say, for 10 days, then that would come out just as a scheduled break, just like any other break. Greg or Luke, thoughts as well?
I would agree with that. Go ahead, Luke.
Sorry, Greg. Yeah, and I think it also, there's I forget which electronic announcement it's in, but they give you guidance on the payment period to use within the calculation itself, and it's based on the timing of when a student withdraws. If you've made a change to the length of your term, but the student withdraws before you made that change, you use the original length of the payment period. And I think if you included them on your reporting to the department, that's the payment period that you would use. Whereas if a student withdrew after you'd made the change to the term length, that's the dates I'd use in the calc and the dates that I would use in the reporting to the department.
That logically makes sense to me as well.
Okay, and I know we are a little bit past the hour deadline. We're going to continue just for a few minutes and answer questions. If we don't get to your questions today, you can certainly reach out to us if you do need to jump off the webinar. Hopefully you can stay with us, and we will just continue for just a few more minutes. We did receive a couple of questions, and I know, Luke, you covered this in the presentation, but to any of you, if a school was required to cease operations for a period of time, so all students are not being instructed, can they treat that as a longer break, or are they required to put all of the students on an LOA and obtain the documentation from them? And if we don't know, that's something we can get back to people. That's fine.
I'm struggling. Yeah. I assume that it's Mike. You want to take a shot?
Yeah, I was just going to say. I mean, obviously, I think you could put everyone at LOA. It seems odd, though. You would have to go back and get the information from a student, though. I don't think you have to treat them as a drop. I'm just trying to figure if you just treat them as LOAs, would you have to even ask them for any information? So I think I just want to think through that, but we can get an answer back on our thoughts.
And I'm
just the best way to document it.
Absolutely. I agree with that. I'm thinking about within the guidance where I think they give examples where if you extended like a spring break because of it, but it kind of implied that it had to be attached to an existing break, which if you just create a break because of the pandemic, I don't know if there's a difference or if that necessarily means that's an LOA. Yeah, I'm not totally sure.
The only thing I was thinking about is like when they have like hurricanes or the natural disasters, sometimes those breaks were not expected during the term, and the department allows you to have that break for that certain period of time. But I'm not 100% sure how they handle each different scenario. But we'll get back on that.
That's a great point, Greg. I think that might very well apply to this situation too.
All right, great. I might handle one, and I guess I'll have you correct me if I'm incorrect, Mike, but we had a couple questions about the waiver for June 30 fiscal year ends, and our assumption or interpretation is the June 30 fiscal year ends will receive the 6-month extension.
Yeah, I certainly think so. I mean, the guidance was a sentence long, and so, as Luke said, we know distance ed's going through 12/30. We know lots of the other relief has gone through payment periods that cross over June 30th. I can't think of any reason why this extension is not applying to the June 30th 20 audits. I think I'd like to clarify that, but that would certainly be my assumption.
Okay. And maybe this will be the last question we get to today. It's come up several times. And is it, when you're reporting the refunds that are not being made because of the waiver, do we have an opinion on whether they should be reporting the gross or the net amount?
You're thinking of because of the loan fees, Dave?
Yeah, I think that's what I'm assuming is the question.
I guess I'll answer and see what Greg and Luke think. I would think you do the net because that's the amount of cash you would have actually returned.
That's the amount you're using in the calculation itself, but that's a great question that I have not thought of or heard from anybody else. Greg?
I would think it would be the net also, because COD knows the original amount, and the amount that they're forgiving for that disbursement would be the net amount for that period of time. So, but we can clarify that one. So,
well, and I'm even thinking EDs. I mean, the net amounts of what you have. So that's what I think I'd put on the spreadsheet. And then, ED may also clarify that when they send the guidance.
So maybe put both for now, just in case. If you're kind of already creating your own tracking spreadsheet, put both, and then you can just delete whichever it turns out that they don't need.
Okay. Yeah, I think that makes sense. And with that, we'll wrap up today. Thank you again so much, Luke, Mike, and Greg, for everything that you presented. Thank you for everybody attended and all of the great questions that we did receive. The software does allow us to collect the questions, and so if we did not address your question, we will make every effort to reach out to you to try to respond. If you don't hear from us, the slides do include contact information. You're certainly welcome to reach out to any one of us. Again, thank you for joining us. We hope you're able to learn something that will help your school remain Title IV compliant throughout the COVID-19 pandemic. Again, we will share the slides, the presentation, all the examples. We will create examples for clock hour R2T4s. I certainly recommend bookmarking our website so we have the COVID-19 updates to our McClintock Minute blog. If you're not already on our mailing list, certainly reach out to us and we can have you added so you're always aware of the updates that we're making. Certainly on that site, the Q&A, we will continue to update, and my guess is many of the questions that we received today for the webinar we'll just add to the Q&A session or Q&A post that we have that already, and then just a reminder about our COVID-19 resources page that you can go for some quick one-page explanations for all the guidance related to the Paycheck Protection Program, the HERF grants, which we didn't talk about much today. We're still hoping there's going to be guidance coming out soon about those, and stay tuned. That could certainly be, any of those could be a topic for a future webinar. And with that, I just thank you again for participating and wish everyone a healthy and safe path ahead. Take care.
Thanks.